Hello, everybody. Yes, Ava, they missed you. They missed you. Ava and her pretty freckled face. All right. I've got her 3 blue Buffalo Health bars out. Hello, Buzzy Pug. Hello, Nana Laura. Hello, Jerry Matthew Boyd. Hello, Manny. Hello, Donald Westerdale. Hello, Joey Bag of Donuts. Just a reminder for tomorrow, it's a rodent, not a meteorologist. Well, it's 6 weeks either way. I love that. Jeez, Ava, you're loud. Chomp, 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 chomp. Hello, C-Rex. Happy birthday to Nana Laura's grandson. Oh, I'm not surprised. Not even a little bit. That's awful. That's absolutely terrible. I'm sorry. Oh my. Hello, Mortimer Duke. Mortimer Duke almost died last night. He texted me. I was not feeling well. and C-Rex had already asked me if she could say that I wasn't coming on, and I'd said yes. Tell everybody I'm not coming on. And so I took more cold medicine. And I was in grumpy la la land because of the pain and the feeling terrible, and then I got a message that said, "Are you going live tonight?" And I'm like, "Who is this?" He's lucky it was him. This is the snow globe one. I love it. It's so comfy. The diamond gems one, I've got it tossed down, but I have to, have enough dirty laundry to do a load. So it's waiting. to get washed. So this is one of them. Hello, Wolf Lord Lover. Thank you so much. I sent Charlie pictures, but I haven't heard from him today. I'm actually really freaking out. I don't like it. He's not feeling well either, and I'm freaking out, man. I don't like it. Hello, Salty Buddha. Hey. Quit chewing on your paws. Quit that. Or if you're going to do that, go in the other room. Come on. Go lay down. No, come on. Out. Ava. Out. You're not going to sit right beneath me chewing on your paws. Go. You're noisy. Well, at least everybody can watch you do it there. Oh, I'm on Dayquil. It's actually very, very close to more Dayquil time. I know, but Morty doesn't look at the group stuff. He just messages me individually. Oh, I so need that. Every muscle in my body hurts. Every single muscle hurts still. I don't know if this is a continuation of the last stuff that I had. The good thing is my O2 stats are fine. Like, I feel like crap. I'm sneezing constantly, and every muscle aches horribly. Like, if I look to the right, turning my head, like, it just hurts. There's that muscle that goes from your upper quadrant to your brain. I swear it's connected. Oh, that strip of muscle is so tight. It hurts so much. And I've been trying to stretch it, but it's just not cooperating. It'll be okay though. It'll be okay. I'll live through it. Hello, Michelle Moreland. That's okay. Thank you. Thank you very, very much. Thank you. I love it. I love these shirts. Charlie gets these super, super, super comfy ones. They're very soft on the outside. They're a lot of times the shirts that you get from, like online ordering, they're really thin material, and they'll cover you, but they're not very warm. These are warm. They're beautiful. They've got amazing colors and patterns, and they're very perfect for Wisconsin. Yeah, but it's you, so it was okay. The first thought through my head was, did Jerry get my number? That was the first thing that went through my head. I was like, I'm gonna kill him. I'm gonna have to find him. And then I'm gonna have to find who gave him the number. Now that he can't get Nana Laura and C Rex to do his evil bidding. Well, I talk to them all day. Are you talking Ava? Yeah, yeah. Well, she she has more experience with them than dogs because she doesn't like dogs. Oh, we might get that. We might get there. I found some fun court stuff. You're in my way. I know you don't care. Stop! I will give you the Ava treatment. Get. Hello, Linda Applegate. Oh, I haven't even started, love. I need some vitamin D. Stop it. Stop it. Well, yeah, I know, but that was a long time and you've never used it. So how was I supposed to know? Actually, a lot of people do because I swear I'm gonna croak on stream one of these days, and you guys are gonna have to call 911. Yeah, StreamYard did a bunch of updates. They changed a whole bunch of stuff. I haven't played with everything. I think this might be what it used to be. They have that. They've got that. And then they've got this. I kind of like this one because you can, it's transparent through it. So it doesn't 100% block stuff. So I don't know. I would hurt you. Uh-oh. Sound has been all right. It's been the videos that have been the problem. The videos, oh man. Like the videos will stop and the sound keeps going. So we'll see. Hopefully it holds out. There we go. I've got to buy that. I've got to buy that. I'm sure it would be available. Ava, sick him. Get him. Just a wee bit. Joey Bag of Donuts has been to my house. He came to bring Ava treats. He had permission. It is okay. I was driving. All right, guys. Not quite, but close. No. That is the I don't know. I love the number, but that is the most useless position that exists. But the number's so much fun. All right. Before we go completely into the gutter, let's let's check this out.
DDC just checking in. Is anyone there?
Are you all set, Your Honor?
Yeah, we're ready. I didn't know if you guys were done with shift change.
Yeah, ready to work. All right. Yeah. Dixon, come on over.
What movie you watching?
They're on the black line right there, bro. It's your full name.
Gerard Dixon.
All right, Mr. Dixon, how you doing today?
So. I'm in court.
So you have the right to talk to an attorney before you're arraigned. Did you have a chance to try to speak with them?
I believe so, yes. I believe the last guy was an attorney. Or an investigator.
Okay.
One of the two.
Okay, would have been probably an attorney. All right. All right, you've got 3 cases in front of me. I'm going to tell you what you're charged with. I'm going to advise you of your rights. Okay. You have the right to remain silent. All right, you are being recorded. Anything you say could be used against you. You have the right to have an attorney represent you, but you do not have to. That is a right that you can waive. You have the right to know what you're charged with and the minimum sentence, which I'm getting ready to tell you. You have the right to ask the government, the court, to call witnesses to speak for you at trial. You have right to hear and question all witnesses against you at trial. You have the right to be presumed innocent until you are proven guilty, or unless you are proven guilty beyond a reasonable doubt, right? And you do have the right to speak at your trial if you speak, if you wish to do so. And if you do not wish to do so, you have the right not to have that option, choosing the option not to speak, held against you. So you have 3 cases in front of me. In your first case, you are charged with aggravated stalking and domestic violence. This is alleged to have occurred back in July of 2023. Aggravated stalking is a felony for which the maximum possible penalty is up to 5 years in prison. Domestic violence is a misdemeanor for which the maximum possible penalty is up to 93 days in jail and or a $500 fine. In your second file, with an alleged offense in May of 2024, you are also charged with aggravated stalking. Looks like both of these have to do with interactions with your mom. And count 1, there's only 1 count in this file. And that is a 5-year felony with a 5-year maximum penalty. Okay.
Oh, you
In your final case, okay, Mr. Dixon, listen,
this
please.
means I'm at this bar. You trying to cook. No one is stalking her. You didn't give me my 30 days to get out of her house. Do you want to get this bar?
Mr. Dixon, remember what I told you. You have a right to remain silent. No one is presuming you guilty at this point.
That's
okay,
right.
it's just
That's right.
quiet,
Mr.
Mr. Dixon. Mr. Dixon.
I have the right to remain silent. And I did not decide to be silent.
You're going to be muted. You're going to be muted. You may speak when I'm done. I promise to give you a turn to speak if you let me finish. Let me finish, okay? I need to tell you what your charges are. It's my responsibility to do that. I'm legally required to do that. So I'm just telling you what they are. I'm not saying you're guilty. I have to tell you what they are. So your final case before me is a charge as a PPO violation. All right, so on your PPO violation case, all right, this one, because it's a PPO violation, you're going to have court tomorrow morning. You'll be in front of the judge on that case first thing in the morning at 9 a.m. This one's a remand. because you have court first thing tomorrow morning. In your other two cases, you're going to have court again on Tuesday. You're going to be seeing a judge on Tuesday.
And who ordered a speedy? This is Speedy. Who ordered a speedy? Did you order a speedy? Why are you speaking for me?
No one's speaking
You
for you.
ordered a
You'll have a
speedy.
chance to speak, Mr. Dixon. One moment. You're still going to have a chance to speak. In each of these cases, bond is going to be set at $25,000 cash with a no contact
You're not getting that
provision with
either. Your
mom
broke ass
and
isn't
no
getting that
contact
either.
with your mother. Please don't make me mute you. I'd like to give you your opportunity to speak if you want to do
Like
so,
I
but you have
said,
to
your
wait till I'm
broke
done.
ass ain't getting that either.
25.
You're living with your mom. Well, you were until you got charged with stalking her after she kicked you out. And you're calling the judge a broke ass? Something not right here. It's the turtle suit.
$1,000 cash. You may not have any contact with your mom or the address where she is located. All right. Now,
And that's right. You're not letting me get my things. You're evicting me illegally, and you're not letting me get my things.
all
She
right.
not put down with the correspondence work.
Would
Listen
you
to
like
me.
to have,
Give me a
would
chance
you
to
like to
speak.
have
Give me-
Mr. Dixon? Do you want to
Give me a
go
chance
get
to
your
speak.
things? Do you want me to have an officer help you go get your things from the house?
Yes, I do. That's what you were supposed
All right.
to do. That's all I want you to do is help me get my things. Shannon Walker, the judge who reinforced this, never allowed me to get my things. Now, if you want to be thrown in prison
Mr.
for
Dixon.
remanding and reinforcing something that's illegal, I will throw your black ass
Mr.
in federal
Dixon,
prison.
Mr. Dixon.
June 4th for bond review hearing, 9 a.m. June 10th for probable cause conference, 8:30 a.m. June 17th for preliminary examination at 8:45 a.m. DDC, see you on the female side.
Mr. Asper, turn on your video. We'll get started. All right. Very good.
Oh, there you go. Sorry.
Okay. On the record, State of Michigan versus William Asper, 2300546 SM. And you are William Asper joining me by video. Is that right?
Good morning, Your Honor. Yes, William Asper, defendant. Well,
All right.
case, yes.
All right, Mr. Asper, you're here for a show cause hearing. Back in May of 2024, you were released from your probation, but you still had a balance of fines and costs. And it's my understanding we need to set up a payment plan on that. Is there a payment plan that you believe would be adequate that you could afford to stick to?
So, good morning, Your Honor. So I had spoken to, I'm not sure what office it was. I don't believe I have any funds to make any sort of payment plans. As I think I said to the court, I am a trustee of an account. I have to pay mortgages, and every month, that account, because of repairs and whatnot of properties, has been in the negative. So I don't have any access to put towards this. As well as what I told the clerk is, since back then, I have a son now, who was born with some a genetic condition. I'll put it. And I mean, it takes my time up. Obviously, there's more money involved, but I don't have any ability to make any payments, Your Honor.
So you need to provide to the court adequate proof of your income and debts in order to prove that you do not have the ability to pay. Otherwise, I do have to continue to attempt to collect this money. What I'm willing to do today is to adjourn this a month to give you time to collect your documents and or consider what payment arrangement you can afford.
Okay, so Your Honor, I have my trustee thing, but I don't take an income from it. So as far as income coming in, I don't have any. So it's zero.
If you're not disabled and unable to work, then you have the ability to work and earn. So that's not going to be an adequate answer.
So I had a question. So there was some recent Michigan Supreme Court case law And since the probation has been terminated, I don't understand what jurisdiction this court has.
It's actually quite the opposite. The Michigan court has determined that in order for you not to have to stay on probation until it's paid, that we retain authority to collect the money after probation. The alternative would be, which they decided they don't want to do, is keep people on probation until the money's paid. So I retain jurisdiction to collect the money. That's my jurisdiction.
That Your Honor, that's not his jurisdiction. I was off probation. That only applies to if I have an ability to pay, which I don't.
Yes, and I'm telling you, I'm adjourning this 30 days for you to provide proof to the court in person of your assets.
Your Honor, I can't go. I don't have a vehicle, Your Honor. I'm not going to be in person. I'm not going to be in person. I have to take care of my child. I don't have a vehicle.
You will come in person, or you will have a bench for it. That's how this
fine,
works.
Your Honor. I don't have a way up there. I don't have a vehicle. I have not had a vehicle since November.
Well, I'm going to go ahead and schedule this, and you'll make your choice. If you're not here, I'll issue a bench. This is set for July 29th.
I'm not showing up in person. I don't have the ability. What email address to send my paperwork to? This is why there's Zoom.
No, so Zoom is in my discretion. And so I do not have to allow a hearing to occur in Zoom. If you want to email records to the court, you can do that. It's Judge Buchanan Courtroom at lansingmi.gov, and I will review whatever documents you submit. But I'm still scheduling this for an in-person proceeding July 29 at 11.
Here, let me get it before we cut out. Judge Buchanan Courtroom.
At Lansing, MI as in Michigan, mi.gov.
lansingmi.gov. Okay.
Correct.
So,
okay. And we'll mail you a notice for that July 29th date. You're all set for today.
Have a good day. Bye.
Unfortunately, July 29th fell into that window of when my drive got AVA'd. So I wasn't able to see if he ever did appear for his hearing. I'm guessing not, because he was a cocky SOB and seemed to think he knew everything. But, yeah, I tried. I did. I tried.
So is this Tony Williams here?
Yes, that's Mr. Williams.
Well, then I guess we'll call the case, Mr. Nagel. We're going to call this case. Come on up, Mr. Williams. On the record in state of Michigan versus Tony Tyrone Williams, 2401392FY.
Matt Nagel for the people, Your Honor.
And you are Tony Williams?
Yes, ma'am.
Thank you. Mr. Williams, you're here for your probable cause conference. We have a preliminary exam set to occur next week on June 7 at 9:30. That's the hearing where the government must bring evidence to demonstrate probable cause to believe these felonies occurred and that you're the person who committed these felonies. In the meantime, we have this complication, which is that you applied for a public defender and you were denied. So you have to make a choice on who you want to move forward. You can retain an attorney at your own expense. You can reapply to the public defender and try to see if they have your income wrong. Maybe they think you make more money than you do. You can choose to represent yourself, but seeing as you are charged with 6 felonies, if you haven't had any legal training, you probably don't want to do that. So what do you think? Do you think you'll hire a lawyer, or you want to talk to the public defender and see if you
talk to the public defender because I don't make enough money to get no lawyer.
Okay. Well, let's see. We have a couple of them here, so maybe one of them can talk to you and resubmit your application. Mr. Freeman, do you think you could help him with that?
It'd be my pleasure, Your Honor. Happy to do it.
Okay. Maybe you have his income wrong because he's saying he doesn't earn enough. Your office said no, so I'm guessing you think he earns too much. All right, so we can do that. So then the next question is, Mr. Williams, your hearing is scheduled for next week on the 7th at 9:30. We can handle that a number of ways. One way is to leave it as scheduled with witnesses, but it's very unlikely, even if they took your case, that they'd be prepared in such a short period of time. We could leave it scheduled without witnesses, just so I can check in with you and make sure that they've made a decision on your application and we know whether you're going to have a lawyer. We could postpone that date to a future date to give more time for you to work on the lawyer situation. Which one do you think sounds like a good idea?
The public defender, because I have no money for no lawyer.
Okay, that I heard. But that wasn't my actual question. Listen to my question again. You have a hearing next week. We can leave it scheduled with witnesses, but it is unlikely a lawyer would be prepared by then. We can leave it scheduled without witnesses so that we can check in with you and see if you have a lawyer by then. I don't know if the public defender will take your case. We're going to try again. We could postpone that date or put it further in the future to give more time to work on the lawyer. So those are your three options. Which one sounds good to you?
Public defender.
That was not my question. Are you listening, Mr. Williams?
Yes.
Okay, so the questions are, do you want to leave the hearing scheduled with witnesses? Do you want to leave the hearing scheduled without witnesses? Do you want me to schedule the hearing for a different day?
You can schedule for next week.
Leave it on for next week.
Yeah.
Do you want me to bring all the witnesses, or do you want me to not bring the witnesses because you're not going to be ready?
You can bring the witnesses because, yeah, you can bring the witnesses.
Okay. When you do that, if the witnesses are here, we're holding a hearing, whether you're prepared or not prepared. You understand that?
I have a question, ma'am.
Yep.
On the altercation.
No, we're not talking about facts of the case.
Okay.
That's not how this works. Okay.
Okay.
One reason is you have the right to remain silent. Anything you say will be used against you. You don't have an attorney assigned to you yet. You should not talk about this with me.
Okay.
Okay. Back to the issue. You want me to leave this as scheduled, which is fine, with witnesses. And what I'm telling you is if the witnesses are here, we're going to proceed. We're not going to waste their time. If they're here, you're not ready, I don't care.
Okay.
Understand?
Yes, ma'am.
Okay. In the meantime, you do have bond conditions, but require that you report to pretrial services. Have you been in touch with them?
Yes, ma'am.
Good. Don't leave the state. Don't commit crimes. Show up for court. Do not use drugs, alcohol, marijuana. Do not possess weapons or firearms. Do not engage in harassing, intimidating, stalking behavior. Do not have contact with Keith Garrett or Robin Uchi Brown. Not to be within 2,000 feet of where they live, work, or go to school. And you have a GPS tether that monitors that you're staying away, right?
Yes, ma'am. But it wasn't altercation when my wife was with her stepson.
Mr. Williams, doesn't matter. You are currently under a bond condition. We will decide that next week, whether that condition.
Everything just, sorry, we're back on, they quit for a minute.
Okay. We'll decide next week whether that condition needs to be modified once I've heard some testimony about the case. I don't know anything right now. I do know this, you're under an order to have no contact. If you violate that order of no contact, you could be arrested without a warrant. This bond you posted could be revoked. You could be in contempt of court, for which you would face up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. This order is about you, it's not about them. If they were texting you or calling you, they can do that. But if you text or call them back, you go to jail. They do not have authority to grant you permission to violate this order because it's the court's order, not their order. So if they invited you to go meet up with them and you went, you'd still risk jail, you see? Yes?
Yes, ma'am.
All right. So we're going to leave this on with witnesses. Understood, Mr. Nagel?
I do, Your Honor. I have a few things for the record before we.
Go ahead.
Just for the record, in case that the issue with the attorney's not worked out by the next hearing, the offer in this matter is going to be plead guilty to count one discharge of weapon in a building, and one count of felony assault. And then the people would dismiss the second count of felony assault and the felony firearm counts.
Okay.
Also, just I think it came to my attention speaking to the one of the victims in this matter that they had intended to address bond and ask for peaceful conditions, but it looks like that Miss Robin Brown has left, so maybe we can leave that issue to the next hearing since she's no longer here to say anything.
I misunderstood what Mr. Nagel had told her. I thought that Mr. Williams had counsel and they'd already had a discussion about what was going to happen. I told her she could address it next week and that I thought they had already dealt with this issue, although I was the first person on the record, so I should have known better. And so she left. I tried to then go run and catch her when I realized that Mr. Williams didn't have a lawyer and she had already gone downstairs in the elevator. So.
Oh no. So in order to change the no contact order, they would have to speak with the witness, and they let the witness go home. Oopsies.
I didn't catch her in time, so it's my fault.
It's fine because I would be unlikely to modify conditions today anyway with so little information about the case.
I just want, since there's no attorney, I just wanted to bring it up so that it was addressed in all fairness to the defendant. But in speaking to the other victim, it has come to my attention that Mr. Keith Garrett, who's also a victim in this case, is in the hospital. So if he's not available at the time of the preliminary exam, I will move forward with the police witnesses. And I might, depending on how the testimony comes out, I might have to seek a continuance.
Okay, well, we will see. All right, so Mr. Williams, I'm gonna encourage you to stop and talk to Mr. Freeman because he is from the Public Defender's Office about your application before you leave, okay? All right, and then I'll see you back here next week.
Thank you.
Thank you.
Thank you, Your Honor.
Mr. Goodrich, are we running Williams?
I believe we're going to be requesting a dismissal. I believe the prosecution is going to be requesting an adjournment.
Well, it's late enough, we can start. Get you done on that, at least while we're waiting for Ms. Stelvero. On the record in State of Michigan versus Tony Tyrone Williams, 2401392 FY.
Matt Nagel for the people.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Williams, who's standing to my left today.
And you, sir, you are Tony Williams.
Yes, Your Honor.
Thank you. Today is the date for our preliminary exam, I think. We had an issue with, initially, Mr. Williams didn't have a public defender. Public defender was assigned later. Supposed to be the date for exam. What's our status?
Your Honor, a couple of things. One of the victims in this matter, Keith Garrett, came to our attention at the probable cause conference that he was in the hospital being treated for something I wasn't able to get to the bottom of. We have, looking at our notes, we had yet to be able to get in touch with that victim. So we will be seeking an adjournment so that we can have an opportunity. He hasn't even been served with a subpoena because of his current location. So we would be seeking an adjournment for that issue. But another thing that we were going to address today is that the people were going to request a dismissal on count 3 and 5. Having been in contact with the victim associated with those counts, she's made it clear that she does not consider herself a victim under these circumstances and will not cooperate with prosecution. That was the people's position this morning, Your
Honor. Dumb question.
Yes.
Wouldn't 3 relate to 6? I mean, is that normally how it goes?
Oh, yes, thank you.
So you're saying you would motion to adjourn on 1, 2, 4, 5, dismiss 3 and 6.
3 and 6, yes, thank
I
you for catching that. I thought I picked the right.
Sure. I just think you relate them sort of
That was
linearly.
The court is correct. Yes, thank you, Your Honor.
Mr. Goodrich, on the motions.
Thank you, Your Honor. Your Honor, we would ask that the matter be dismissed in its entirety at this time. They have one witness that they've been in contact with, and she has stated that she does not choose to participate for whatever reason. Mr. Garrett is her son. I believe that they have had contact with, can't remember her last name, Robin, what is her last name? Brown. Okay, Miss Brown, regarding that, that is the best contact they're going to have regarding that. They're still not able to get in contact with him. I would ask the court to dismiss the matter in its entirety. If they find him and he wants to proceed at some point in the future, they're certainly welcome to refile the charges at that time. But at this point, we have no idea what kind of time frame they'd even be looking at. So we would ask for dismissal in this matter.
All right. As to the motion to adjourn, because the witness has been in contact with the prosecution and asserted that he was hospitalized and we don't know his medical status at this time, because Mr. Williams is in fact out on bond, I'm going to give them a brief adjournment to make contact with the witness. This preliminary exam is reset to, I believe it's going to be the afternoon of June 20. We'll add it to the 3 that are there. June 20, 2 o'clock. But in the meantime, on prosecutor's request, I think we're gonna generate a nollie for counts counts 3 and counts 6. So that those are taken off the file immediately. Just so you know, Mr. Nagel, based on the adjournment for this reason and defendant's objection, there will be no further adjournments on June 20th.
I anticipate that
Unless
being the case, Your Honor.
something absolutely outrageous occurs between now and then.
And based on the dismissal of the counts involving Ms. Brown, may we address the tether, him having a tether on at this time?
You could leave the tether, but I can remove her from the no contact.
We'll settle for that, I guess, for now. Yes, Your Honor.
Okay, amend bond to remove Robin Gucci Brown. So the order will remain intact, no contact with Keith Garrett, not to be within 2,000 feet of where he lives, works, or goes to school. So that will continue to be the order only as to Mr. Garrett. As to Ms. Brown, that will be removed. We'll give you an amended order in a minute.
Your Honor, regarding the tether, that location is the residence of Robin Brown and not of Keith Garrett at this time.
I don't know that. I think the affidavit of probable cause said he lived there, didn't it?
Back in February when this incident occurred.
Well, until I know from someone that Mr. Garrett's not there, that continues to be.
Okay.
I mean, the address follows him, and so until we know a different address for him. Because the weird counts do them separate.
Yep.
Sorry.
No, that's all right.
So court notice, a bond, and copies of the 2 charges that were dismissed. Okay. All right, have a seat, please. All right, you all set? We've got Mr. Gordon now. Do you need to speak to him?
I don't have a means by which,
Well, we can
I'm
put-
without a phone or a tablet. I'm
We can
sorry.
put you on an iPad if you'd like. Do you need to speak to him? We can arrange it.
That would be fine.
Mr. Hannah, can you grab one of our iPads and we'll get him logged in?
Is there anyone right back in the witness room?
I didn't send anybody back there. If the iPads aren't back there, they're on the ledge in our office.
Okay.
You know, the window ledge thing.
Yeah.
We can do this.
I think we're gonna be able to help Mrs. Williams.
Oh, that would be good.
Yeah,
It's tough for somebody to come in with like 6 felonies and no lawyer.
well,
Made me worried.
When they're asking for help, yeah.
Yeah, true.
it's not my
They don't
decision, of
want-
course, but I think I'm gonna be an advocate on his behalf, so.
A lot of
Thank
felonies.
you. I'm sorry to take the time, but yeah, I
Oh,
really
no,
should say
if you
hello.
need to talk to Mr. Gordon, we're happy to facilitate that for you.
Should I follow your court officer? Is that?
He's right there and hopefully I can get you into a breakout room.
And that's where the case got away from me. But hey, at least we learned that Mr. Williams has an advocate on his side now, and they think they'll be able to do something to help him. I'm assuming that that lawyer did everything from then on via motions. And considering the stepson was in the hospital for an indeterminate length of time, and the mom was unwilling to prosecute because she didn't feel like a victim, I'm thinking they probably got the charges dropped for now. But yeah. His first hearing was the most comical. Hello, Metal Rules. Hello. Oh, dude, I watched through the time that I was sick. I watched probably at least 18 hours of court, of terrible court, boring, terrible, snore fest court in order to find you these few gems. So after hearing Jerry talk about how he's gonna get tickled in the morning, I don't know. I don't know if I want to be tickled like that. Leave it to you, Manny. Leave it to you. I love you.
If there's going to be a misdemeanor plea, we need a plea sheet that outlines the plea agreement.
Oh, I just have to do a quick, brief disclosure. This case is from a couple years ago. You'll know why in just a few minutes, why I'm making that disclosure.
Still looking for a plea sheet.
I have a copy of.
Oh, I see. It's a different version than what we normally use, and I didn't realize it was under here. Because the advice to rights is double-sided, you know, we usually use double-sided in our court files. I think that's even in the court files. Okay. What are the possible penalties for the plea offense?
Oh, the plea, it was the misdemeanor, the 90-day misdemeanor,
It's a 90-day and or
$500.
500. Mr. Nyampakudza, is that your understanding as well?
It is. Excuse me. It is, Your Honor.
So the other thing that's just specific to our court, that's weird, is if we keep it here, we amend the count, we don't add the count.
Okay.
I don't know. It's our clerks. So if it stays in district court, we amend the count. If we send it to circuit court, we add a count.
Count one.
Yeah. So I'm gonna change it on here as well. Just gonna put one. Amended. On the record in state of Michigan versus Carmen Fahey, 2401163FY.
Good morning, Your Honor. Alex Peterson on behalf of the people, P80971.
Good morning, Your Honor. Takura Nyampakudza on behalf of Carmen Foy, who is present and standing to my left.
And you are Carmen Fahey?
Boy,
Irish and Gaelic. Okay. Thank you. Today is the date for preliminary exam, but I received a plea agreement. This says that the Attorney General's office is offering a misdemeanor welfare fraud, failure to inform 500 or less in lieu of the original charge. Further, a delayed sentence. It does not say how long the delayed sentence is to be, but delayed sentence under 771.1 with terms and conditions of which I guess I get to pick the terms and conditions since the only one mentioned here is restitution. No upfront jail, dismissal upon completion of the delayed sentence. I think that's what I have. Is that a full statement of the offer?
That's correct, Your Honor.
It is, Your Honor, and I know we haven't reached that juncture yet, but I think even, or perhaps not today, but within a week or so, we are in a position to pay off the restitution. So just wanted the court to be aware of that.
Okay. And Ms. Foy, this is an offer you're interested in taking today?
Yes, Your Honor.
Okay. Welfare fraud, failure to inform is a misdemeanor punishable by up to 90 days in jail and or $500 in fines plus court costs, restitution, and misdemeanors can carry up to 2 years of probation. You understand the possible penalties?
Yes, Your Honor.
Some criminal convictions can have other consequences. If you are a citizen, foreign travel may be restricted. If you're not a citizen, you may be removed from the country, excluded from admission to the country, or denied naturalization as a citizen. You have an agreement to delayed sentence. Delayed sentence is a maximum of up to 1 year under MCL 771.1. And the agreement is so long as you satisfy, I guess, terms and conditions, kind of vague, the case is dismissed. If you are unable or do not satisfy those conditions, the charge would of course stay on your record, and then you'd ultimately be sentenced on the charge at that time. Is that your understanding how this is going to work?
Yes, Your Honor.
You have the right to have an attorney in this matter. Mr. Young Kakutz is representing you. You have the right to a trial that could be by jury. Did you have an opportunity to review and advise the rights and plea information?
Yes, Your Honor.
And you signed this document?
Yes, Your Honor.
Have you had the chance to ask your counsel all your questions?
Yes, Your Honor.
Do you understand that if you proceed with pleading guilty, you'll give up each one of these rights? There will not be a trial of any kind.
Yes, Your Honor.
If you were on probation, parole, or bond on the day this occurred, pleading guilty could result in a probation, parole, or bond violation. As a result of that, you could receive a consecutive sentence for your probation, parole, or bond violation. Are you ready to proceed with your plea?
Yes, Your Honor.
Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
Yes, Your Honor.
We're going to proceed with the factual basis. It's going to be a little bit,
Pardon the interruption. If the court will allow, I think I could do that pretty.
so based on a discussion with the chief judge of the circuit court, I believe I have to attempt it myself first before I can turn it over to counsel.
Yes.
Okay. Ms. Foy, between the dates of June 6, 2021 and April 9, 2022, were you receiving, I guess, a public benefit?
Yes, Your Honor.
What was that benefit?
Daycare.
Like a supplement that helps you pay for daycare? Is that what it was?
Yes.
Well, that's what I'm asking, because you said you were, it says that you're agreeing that there's some kind of,
Overissuance. Yes.
pardon?
Yes.
I didn't understand the word.
Oh,
Separate.
an overissuance of benefits.
Overissuance. So I'm asking, you were receiving a benefit.
Yes.
You're saying that benefit was related to daycare.
Yes.
Okay. And then what happened with your daycare benefit that makes you guilty?
It stayed open longer than it should have.
Well, how so? Did your income increase, making you ineligible for that benefit, or you no longer needed to put the child in as much daycare because you weren't working as much?
It was COVID and at times she was home with me, but the daycare case stayed open longer than it should have because I adopted her in August of 2020.
Okay, so then she wasn't going to daycare because of COVID, is what you're saying?
But the case was still open.
Sure. Answer my question.
Okay.
She wasn't going to daycare because of COVID.
No, not till.
She was staying home with you.
Yes.
Okay, but then did you receive some kind of benefit as a result of that case being open?
The daycare provider was paid even though it was closed because the case was still open and it was COVID. She did go back to daycare in April 2021.
So you're saying you yourself did not receive the benefit the daycare provider did?
But if the daycare had been open, I would have received the benefit and the case was not closed. It was still open.
Sure, I'm asking who profited from this failure to this leaving the case open when it wasn't being a service being used. And you're saying the daycare profited, not you.
But when she went back in April, I profited.
Meaning they said you have a credit on your account?
No, they just billed and she was there in April.
I don't understand how that means you profited. Then you're receiving a service and they're being paid for that service.
I guess when, to my understanding, during COVID, even though daycare was closed, daycare providers were allowed to be paid to keep that service open when the pandemic was over.
Okay, how does that mean that you've committed a crime?
Yeah.
Yes.
Ms. Foyle, on the 12th of August in 2020, did you in fact adopt Vivian Green?
Yes.
And at the time, were you an administrative law judge here in the state of Michigan?
Yes.
Oh, she's a judge? She's a judge. And she's pleading to committing welfare fraud, which just so happens to be daycare fraud. And this is back in 20 and 21. And she had to get the tears going. You see that? Her attorney had to give her the box of Kleenexes so that she could get her tears going.
And at the time, were you an administrative law judge here in the state of Michigan?
Yes.
Because of your position, before the 12th of August, did you qualify for the child development and care benefits for Vivian because she was a foster child?
Yes.
And because she was a foster child, that was the only reason that you were receiving that benefit?
Yes.
And after the 12th of August in 2020, did you submit a form to the Department of Health and Human Services called a redetermination,
Application. Yes.
And on that redetermination, if it had been stated explicitly that you had adopted her and she was no longer a foster care child, you agree that you would not have continue to receive that child development and care, shortened to CDC benefit?
Yes.
So in fact, the Department of Health and Human Services relied on that redetermination that you submitted after Vivian had been adopted to continue paying that child care development benefit.
Yes.
And was the amount $499.99 or less?
Per what? Total?
Total, yes.
Wow.
I think that for the misdemeanor, the amount is $500, Your Honor.
Sure, but of course, as you well know, the factual basis can be to the original charge, and I don't want her to misrepresent the facts of the case to try and squeeze it in the misdemeanor because she's under oath.
Okay.
So we should give honest testimony.
Okay. Yes. Would you agree that it was more than $500?
Yes.
Okay, so to be clear then, once you adopted and you did the redetermination, you failed to disclose that she was adopted.
Yes.
Okay, and then as a result of that, the benefit kept getting paid to the provider.
Yes.
And then there came a point where you started to even use the provider and the benefit was paid on your behalf.
Yes.
Okay, so there was a time where not just the daycare was getting paid while she was at home with you, but they continued to pay once you used the service.
Yes.
Based on not knowing that she had been adopted.
Yes.
I see. Okay. Anything else on the factual basis?
Just one question for Ms. Bay. Was the amount that was overissued $6,741?
Yes, according to the department, yes.
I have nothing further.
When you submitted that redetermination, you obviously knew you had adopted your child.
What I will say is that when I was fostering my daughter, she was very sick. And so but it was like a village. The foster care worker, the CPS worker, the daycare worker, the Medicaid worker, they all helped me because I was at U of M, still trying to work full time. I was still traveling for work, so it was a lot. And so
I am trying to get the last of the factual basis. I'm not
Okay.
trying to get your mitigating circumstances or.
Okay, yes.
Okay, so you knew you'd adopted and you knew you had failed to disclose that?
I didn't read the redetermination. She normally filled it out for me and I just signed it and I was overwhelmed and I didn't read it.
Okay.
So I just signed it and sent it back and it still had foster care worker, foster child on it, and I did not notice.
You signed that document?
Yes, I did. So,
And so you should have known.
and I should have read it.
That it
Yes.
was not accurate information.
Yes, and I did not notice. Yes,
And you probably also should have known that you weren't going to qualify for that benefit anymore.
I did know.
And so when you continued to receive that benefit, you should have known you shouldn't have been getting it.
Well, Yes. What I would say is that, even though she was adopted in April, it continued for a time after, and I didn't know when it ended, but it would end because I wasn't eligible because of my income,
Right.
and it did continue.
Sounds like for a while.
Yes.
Anything else from council?
No, Your Honor.
Well, it continued for a while, yes, but it ended far before it continued. They just didn't know it yet. And Your Honor, the reason why it's not going smoothly is because she's doing everything in her power to take accountability without actually taking accountability. There's an excuse. There's always an excuse. I didn't read it. My daughter was sick. Someone usually fills it out for me. I just signed it. Come on. You knew you weren't eligible. You found a way to slip it through by not changing that she was no longer a foster child. And you did it. End of story. You did it. You are a judge. And you committed fraud. And you preside over cases. You are to be held to a higher standard. How can anyone trust you as a judge now?
No.
Alright, I think we had to make sure we had the mens rea in the
Okay.
record because this isn't a strict liability offense. It has to be with intent to defraud. Although Ms. Fahey or Ms. Foy has tried to sort of put that this is accidental into the record.
Oh, no, that was not my intention. I'm sorry.
And of course, there has to be intent to defraud.
It is.
Mr. Nyampakudza, are you satisfied that your client has provided a factual basis that includes all of the elements, which include the mens rea necessary for this?
Yes, mens rea and actus reus, yes.
Ms. Foy, did anyone make any promises or threats to you other than this plea agreement to get you to plead guilty today?
No, Your Honor.
Are you pleading guilty of your own free choice?
Yes, Your Honor.
Then to an amended count 1, the misdemeanor welfare fraud failure to inform, 500 or less, how do you plead?
Guilty, Your Honor.
And your guilty plea to be knowingly, voluntarily, accurately made with sufficient facts on the record upon which to base your plea, it's therefore accepted. I don't think that we have a crime victim rights issue in this case, so I can proceed with the immediate delayed sentence if the parties are amenable to that. If you prefer I set a date, I can do that.
People are fine with proceeding right now.
Likewise.
All right, on behalf of the state of Michigan, go ahead for sentence.
But we would just ask that Your Honor follow the plea agreement in this case, specifically with the restitution amount of $6,741 and 45 cents pursuant to the delayed sentence statute.
Let me ask you this, though. You contemplated that there's going to be compliance with some acts to earn a dismissal. And I want to know what things you contemplated that would be done aside from paying restitution. Because the sentence could be delayed up to a year. I imagine if Ms. Foy can pay the money and get a dismissal and that's all you wanted, we could have just adjourned this another week. She would have paid the money and we wouldn't have even taken the plea. So.
So that is correct, Your Honor, and I do apologize for any confusion. I know every court is a little bit different, so I just tend to include that language if the court wants to impose any other conditions, but our main concern here is the restitution repayment. So if we need to come back in a week or so and I can.
Well, I guess I'm confused about why did we go through the exercise of having Ms. Foy plead guilty if all you're trying to do is collect restitution and she's saying she'll have it in a week? Is it Because if she would have paid it today or yesterday, you probably would have dismissed if that's your goal in the end is get the money and dismiss. So I'm confused about why we took a plea today. If she's gonna pay the money next week and we dismiss the case next week, why would we have gone through this exercise? So I'm trying to figure out what else we're trying to do here.
So I wasn't sure she was going to be able to pay it in a week. I wanted to give her the probationary period to pay it all. I didn't know it was gonna happen so quickly. That was the intent behind the plea today.
So you just weren't confident that even though she said she had the money within a week, that it would happen within a week?
That's correct.
Okay. Mr. Nanthakuta for sentence.
Well, it's not like you can trust her.
I would ask the court to follow the agreement, and I don't believe the court has any reason to believe that Ms. Foy will end up in front of a court for any other reason. She is an active member of the community. I won't go through the many lists of organizations and things she's done to benefit this community. And when she speaks about the village, I know that, matter of fact, I was one of the people that she mentored when I was in law school. And I don't think this is something, the sort of thing a court can take judicial notice of. But again, Ms. Foy is a very active member of the community. And given that, again, we don't have a crime rights victims issue here, I just ask that we be allowed the shortest amount of time and have this dismissed pursuant to the agreement.
The other thing that just occurred to me is, don't you both now have an affirmative obligation to report this plea to the state bar?
Yes, we do.
Report this plea to the state bar.
Yes, we do.
I believe you do. So that's the other part about this. So we went through this exercise and the state bar will be informed, which may or may be the appropriate outcome based on the nature of the incident. I don't know. Okay. Ms. Foy, anything else you want to tell me to consider for sentence today?
No.
The other part, of course, is as I've taken a plea, there will be mandatory assessments that I will have to make. There will be the restitution, of course, which apparently is agreed to be $6,741.45. Council, there are those forms in front of you underneath the play sheets. We need that filled out as best you can so that we know where to send the restitution money.
Okay.
Yeah, the way she shook her head, it almost seemed like her begging them not to. It didn't seem like her answering a question. It was like, no, please don't. Please don't. Oh my gosh. Linda, I love you so much. Thank you. I was actually trying to hit you with that, with the 5 gifted memberships. I was hoping you'd get one. But I'm so grateful. Thank you.
So they want to know where they have to actually send it.
Okay.
Because now it's through the court, the money goes through the court. $75 crime victim rights fee, $50 state minimum costs, $100 fine, $6,966.45. We'll set this on the calendar for 60 days out for the deadline of the delayed sentence to have the dismissal. The only other conditions of your delayed sentence are the typical, when you're under supervision of the court, don't leave the state without notifying us, don't commit any crimes.
To that point,
Mhm.
We had a travel request submitted for Ms. Foy to go to Alabama on a trip with her daughter for an NAACP educational experience, and we would ask that the court grant that, because her daughter is too young to travel on her own.
Not filling out this thing from pretrial because you won't be on bond anymore, so they aren't in charge of it. Oh, so I just included here, and Mr. Warrensley, I don't know if you have to actually update her bond because she's technically not on bond when she's on the late sentence. So maybe not.
Okay.
Do we have a date 60 days out for this file? August 12, 8:30. Actually, can we move that up a week?
Okay, Ms. Foy is in a position to pay today the restitution as well as whatever fines and costs have been assessed. So I don't know that we will need the 60 days.
The agreement was a delayed sentence, so I don't know. I put the 60 days on there because we had to come before the court, so
Understood.
change it to 30 days of delayed sentence, but I feel like I have to comply with the terms and conditions. There has to be a delayed sentence for the.
Yeah, what a wild thing, Judge, having to comply with the law. I mean, it's almost unheard of these days.
Okay, Ms. Foy is in a position to pay today the restitution as well as whatever fines and costs have been assessed. So I don't know that we will need the 60 days.
The agreement was a delayed sentence, so I don't know. I put the 60 days on there because we had to come before the court, so
Understood.
change it to 30 days of delayed sentence, but I feel like I have to comply with the terms and conditions. There has to be a delayed sentence for the dismissal. I don't think we just dismiss it today. Okay, 30 days. July 8th. 8:30, okay. And that will be the date that, if the prosecutor is satisfied, I would expect a nollie by then. I guess if I received it.
Yes, ma'am.
A dismissal before then, of course. But again, as this case came through the court, all the money has to be paid through the court, which means there may be a delay between your payment today and their receipt of their restitution payment. But of course, if we have it and we know it's going, we would of course tell her that.
Now, write a check or does it be a cashier? How does it?
Will the clerk's office take a check, David? Do you know? I can't remember.
I believe, let me double check. I believe so. Let me go double check. So they said they won't take personal restitution.
Okay, cashier's check.
Let me,
MCR 9.120A requires your notification to the grievance administrator and the conviction within 14 days. I think we're done on the record with this. It's just Mr. Wormsley trying to figure out what form of payment you need to bring back.
they'll take cashier's check.
Okay. So,
Thank you.
thank you. All right. And we set it for July 8 as the deadline based on your representation that you can do that ASAP because you just want to be done with us.
Thank you.
Thank you.
I take down with the file.
Okay.
Over the same case.
May I have your name, please?
Christopher Buswell.
Good afternoon, Mr. Buswell. We are on the record in case number 24-3290FY. You're appearing for arraignment purposes. This afternoon, you're appearing with Ms. Mistley, the defense attorney available through the Indigent Defense Counsel here to assist you. And Ms. Mistley, did you have opportunity to review allegations on the complaint, the nature of the offense, and the possible maximum penalties with Mr. Buswell?
I did, and we will waive a formal reading of the felony complaint. I believe Mr. Buswell does in fact understand the allegations, the nature of the charges, along with the maximum penalties, both with and without the offender notice. Will enter pleas of not guilty and request counsel.
So in order to complete a petition for court-appointed attorney, I need to place you under oath and ask you some questions. Would you please raise your right hand? And you swear that the information you're about to give me will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you, and you're welcome to lower your hand. Mr. Buswell, what is your phone number?
231
And what is your mailing address?
West Traverse City.
Do you use an email address?
Yeah, I do.
What is that?
At Gmail.
At the address on Hammond, are you renting, purchasing the home, or living with others?
Renting, living with others.
Are you employed?
Yes.
Where do you work?
Self-employed construction.
What's your average take-home pay?
$4,000 a month.
Do you receive any other source of income or assistance?
No.
Do you own a vehicle?
Not at the time, no.
Do you have any money in a checking account, savings account, any cash on hand, or any digital currency?
No, not yet, but I will have some soon.
Well, what will you have soon?
I'll have in my bank account $97,000. That's why I want to try to
When will
lower
you
the
have that
bond.
available?
When will I have that available?
Right.
Shortly. I'm just waiting for it to come back from Canada.
To come back from Canada? Wait a minute.
Do you receive any other source of income or assistance?
No.
Do you own a vehicle?
Not at the time, no.
Do you have any money in a checking account, savings account, any cash on hand, or any digital currency?
No. Not yet, but I will have some soon.
Well, what will you have soon?
I'll have in my bank account $97,000. That's why I want to try to lower the
When will you have that
bond.
available?
When will I have that available?
Right.
Shortly. I'm just waiting for it to come back from Canada.
Well, if you are going to have $97,000 in your bank account within the next few weeks, then you certainly would be able to hire your own attorney, right?
Hopefully, that's why I'm trying to do a power of attorney here and trying to get my bond lowered to at least a 10%, so I can handle of my affairs and everything so I can bond out and handle them affairs.
So how is it that you're getting money from Canada? Is it
I'm a
the
tribal
payment
member.
of services? I'm sorry?
I'm a tribal member in Canada, and they had some old treaties come back, and us tribal members got treaty payments, old treaty payments.
Buddy, I think you're being scammed.
And I do plan to hire my own attorney after, I get the money into my bank account. It's been a month and so waiting for it to clear back from Canada. So it should be coming really soon.
So my concern, Your Honor, of course, is that either A, the money does not appear, or B, does not appear in time for keeping in mind the 21-day rule on the preliminary examination.
Oh, the money is going to appear. The money will be there, but yeah, I don't know within the 21-day thing, maybe not.
All right.
It's hard to tell on the things. That's why I was going to go with court appointed.
For you. I will appoint an attorney for you. I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning. If you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. You have the right to a preliminary examination. In this case, it would be scheduled for December 16th at 11 a.m. with Judge Stepka. Also, on December 9th, you would have a probable cause conference. Ms. Mistley, bond has been set in this case. Do you have information you'd like me to know regarding bond?
So Mr. Bourgeois is requesting that that be lowered. Apparently it was set over the weekend as a cash or surety. 50,000 cash or surety bond. He is requesting a 10% bond. He does have 2 children that he supports, ages 12 and 16. He is not on probation or parole. He's been steadily self-employed for the last 10 years. He's resided in this area. I do know that the praxis says history of failure to appear in 22 and 23. It's impossible really to review that with him without any more information. But it does appear that he's had successful completions of probation in the past. So for those reasons, we're requesting a 10% bond.
So, Mr. Bourgeois, I am not going to change the bond. I'm going to continue the bond as it was set. The court's concerns are certainly that you do have a known failure to appear, that your criminal history is significant, that you've had 2 or more felony convictions in the past 5 years. You have multiple felony convictions. This is a situation that I believe threat to public safety is also a concern. So the bond will be continued with all of the same terms and conditions. You should hear from your court-appointed attorney by the 1st of next week. Again, your preliminary examination will be December 16th at 11 a.m. And for right now, then you are all set.
Oh, he's gone. Oh, man. Thought that was,
Good afternoon, are you Mr. Gorley?
Good afternoon.
And you are Matthew Gorley, is that right?
Correct.
Sir, we're on the record in case number 24-3019 SM. You're appearing for arraignment purposes this afternoon. Ms. Mistley is the defense attorney available through the Indigent Defense Counsel who will be assisting you with this arraignment. She's not yet had an opportunity to speak with you, so I'm going to ask to place you and Ms. Mistley in a breakout room so that she can go over the issues regarding the arraignment before we begin, okay?
Thank you.
Yes, you're welcome. Thank you and welcome back. We are back on the record in case number 24-3019 SM. Ms. Mistley, did you have opportunity to review the allegations on the complaint nature of the offense and the possible maximum penalties with Mr. Gorley?
I did, and we will waive a formal reading of the misdemeanor complaint and her pleas of not guilty, and Mr. Gorley intends to hire counsel.
So the next step in the process, Mr. Gorley, the pretrial conference in this case would be scheduled for October 29th. It's at 9:30 a.m. It's an in-person appearance here at the district court. Please make sure that you're in contact with an attorney as quickly as possible so that your attorney can properly represent you at that pretrial conference. I need to verify some contact information with you, please. Mr. Gorley, what's your phone number?
231.
And your mailing address, please?
P.O. Box, Traverse City, Michigan, 49684.
Thank you. So Mr. Olson is here from the prosecutor's office. And Mr. Olson, for the people, do you have information you'd like me to know regarding bond?
Yes, Your Honor. First of all, Mr. Gorley is currently on bond on 2 separate matters. One is a trespass case. The other is a resisting obstructing police officers, 2 counts. That latter case of resisting and obstructing police officers is actually scheduled for trial at the end of this month on October 30th. Mr. Gorley also has a significant criminal history as it relates to alcohol-related offenses. He has, I believe, 1, 2, 3, 4, 5, 6 OWI prior cases, as well as a domestic violence conviction in 2006. In addition, we're still awaiting reports in this case, but it's our understanding that we're going to be receiving information regarding a third victim that is currently not the subject of account. And so I would like to provide that name and address to the court of that individual's work address to include in a no contact order. Based on the totality of the circumstances, Your Honor, we would be asking for a significant cash bond as well as a GPS tether. And also we would ask that the court order a baseline urinalysis and that Mr. Gorley be subject to drug and alcohol testing at the discretion of community corrections. And I can provide the name of the third individual in addition to the 2 victims that are referenced in the complaint. Matthew Quigley and Nathan Jewett are the 2 in the complaint. And then the third individual that we would be requesting that no contact order be entered would be Diana Johnson. And I can provide the court with her work address. I believe Mr. Gorley is previously aware of that address, but I can provide that to the court.
Unbelievable.
Go ahead, you can provide that to me, sir.
Ms. Johnson's work address is Racket Club Drive, and that is in Traverse City, and the zip code is 49684.
Thank you. Ms. Mistley, is there information that you'd like me to know regarding bond?
Well, there is. So Mr. Gorley is a lifelong resident of this area. He grew up in Traverse City, has resided here throughout his adult life. He has been self-employed in the construction industry for a number of years. I've previously represented Mr. Gorley, found absolutely no difficulty communicating with him. He appeared when he was supposed to appear, where he was supposed to appear, whether it was in court or with appointments with me. While I certainly, given the allegations, we have no objection to any no contact order. I think the request for a significant cash bond is not called for. There's no indication of violence here. There's no indication of a violent history other than a misdemeanor DV case nearly 20 years ago. There's no allegation that he's failed to appear in the resist obstruct case or in the trespass case.
So resisting and obstructing an officer is nonviolent? I mean, it can be, but it typically isn't. And they usually downplay the severity of it. So, yeah, I'm not buying it.
I don't think that we have any reason to fear that he will not show up. In terms of a GPS tether, I just don't think that this complaint that alleges malicious use of a telephone justifies the imposition of a GPS tether requirement of bond. Thank you.
Mr. Gorley,
Yes, ma'am.
your bond, the court is concerned about the nature of the allegations in this complaint with regard to the 2 victims that are listed. Mr. Olson from the prosecutor's office has indicated that there is going to likely be an amended complaint with another victim. I do see your criminal history, and it is significant as far as alcohol-related convictions are concerned. I believe that you do pose a threat to named others. I believe that there is reason for the court to be concerned of public safety as well with regard to the convictions for operating under the influence in your past.
So for those reasons, your bond in this case is going to be a $10,000, 10% bond. Conditions on the bond are you may not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You'll provide a list of your current prescriptions to the district court clerk. You will be required to have a continuous alcohol monitor, and that would be supervised by Community Corrections Pretrial Services. You will submit to discretionary PBTs and discretionary urine screens whenever requested, again, by a police officer or any court personnel, so you can't refuse. You will have an immediate urine screen and once per month urine screens hereafter. You may not enter a bar, casino, or any place that serves alcohol by the glass. You'll have no contact in any manner whatsoever with Nathan Jewett, Matthew Quigley, or Diana Johnson. That means no phone calls, no messages through other people, no mail. You may not text message nor through any social network have any contact with any of those individuals. You'll stay 500 yards or more away from each, so you may not be at any address that they are or may be. You may not go to Racket Club Drive in Traverse City. You may not use nor possess any weapons of any sort. You will have no threatening, intimidating, harassing, or violent behavior towards any person. You'll be respectful of all court employees and care providers during the course of your case. You may not use the internet or computer for anything other than work-related activities or personal finance. No communications with certainly the named others, and no communication that are threatening in nature to any person. You may not access social media.
For 1 year misdemeanor?
In order to, I'm sorry, social media in order to intimidate, harass, or threaten any person. If you post the bond, be sure that you immediately make contact with Community Corrections Pretrial Services, as they will need to place that continuous alcohol monitor on you. And so if you're not released before, my guess would be before 3 o'clock today, and if you post that bond, you'll need to appear for your continuous alcohol monitor first thing in the morning. And you'll need to appear for your urine screens this evening, and you'll take a PBT at New Directions at the same time.
Ma'am, have an interlock in my pickup truck, can use that daily.
Well, you'll need to use that in order to drive, but the continuous alcohol monitor will assist in ensuring the safety of others while you're not in your vehicle.
Mr. Olson, can you share with us what is at that Racket Club Drive address?
That's the office of Diana Johnson.
Okay,
It's an office.
She's my counselor. Why wouldn't I be able to see my counselor?
Okay, hold it, Mr. Gorley, hold on, because you can't see her. You'll have to find a different, you will have to find another counselor. I just wanted to make sure that wasn't New Directions. Okay.
It is close to New Direction.
Is it
so
within
they
500 yards?
I'm not sure of the yardage, but they are in close proximity.
Well, the no contact order is superseding, so make sure that you understand. You can go to New Directions for your testing, but you cannot have contact with Diana Johnson. So if you see her on a sidewalk, you see her driving in, it's your responsibility to have absolutely no contact. So do you understand that, Mr. Gorley?
Absolutely. I feel like it's an attack against me, but it's all right.
The no contact orders are in effect immediately. So if you don't post the bond and you remain incarcerated, No contact even while you're incarcerated, right?
Correct.
Ms. Missley, do you have any other questions, ma'am?
I do not, thank you.
Call for
Mr.
misdemeanor.
Olson, anything?
No, Your Honor, thank you.
Thank you. You're all set, Mr. Gorley.
Thank you all.
Thank you, Your Honor.
So the charges were something to do with something to do with cell phone communication. So, and something to do with alcohol. So my guess is he got himself extremely intoxicated and then either drunk dialed or drunk texted his counselor and those other two people. And apparently did some questionable things because he can't even use social media now. Well, I mean, he understands. He just doesn't think he deserves it. For a misdemeanor? She's my counselor. Oh, did something, buddy. Ooh, that's a possibility. I can't say you're wrong. All right, guys. Oh, golly. That's so dumb. I'm not surprised. It was bound to happen eventually. But that's so dumb. I just need it to make my toast. That's it. I'm not gonna marry my frickin' toaster. I don't want the ring bearer to be the ice machine. Keep your appliances appliances. Oh, I'm glad you made it too, sweetie. I am gonna go take more cold medicine and I'm gonna go to bed. I am very, very achy still and I'm tired. I'm sure I look it. Jeez. Oh, Salty. Something wrong with you, buddy. I love you, though. Earl's got the right idea up there. He's super comfy. I love you. And dag nabbit, Charlie. I have been texting you all day. Worried sick. I'm really grateful that you showed up to the stream, so I at least know you're alive. I hope you all have a wonderful night. Be safe, be well, sleep sweet, and much love.